And Mr. Whitney, if you could come to the other podium in the interest of time.
Chairman Christie, members of the commission, I'm Andy Caldwell representing COLAB. Your county council did an excellent job, in my opinion, of summarizing the message from the grand jury. The fact is that message from the grand jury wasn't to the planning commission as much as it was to one planning commissioner. This one planning commissioner was characterized by the grand jury as being anything but a non-involved reviewer, and indicated in more than one occasion that there was a high probability of bias. And the question here is, are the people in this room going to get a fair hearing? There's a difference between an opinion and an agenda. And the question is, how many of the planning commissioners came here today with an agenda? And the Brown Act, which governs meetings, the preamble of the Brown Act says the people do not yield their sovereignty to their elected officials or their appointees. They have a right to a fair hearing. They have a right to an open meeting process by which they are noticed before the meeting begins of any collective concurrences that may have occurred, any writings or ex parte communications, and or in this case, communications from one planning commissioner to the other planning commissioners, or a planning commissioner to an organization like the Sierra Club, where they've stated before the hearing began what their position was going to be. That is prejudging the outcome. Prejudging is where we get the word prejudice. And of course, that is akin to the word bias, which is why the grand jury, which is an apolitical organization appointed by a judge with no political axe to grind, they're a watchdog. And the fact that the Board of Supervisors blew off their recommendations, in our opinion, is a travesty of justice. We have raised questions about Chairman Christie disseminating information and her positions to each of the planning commissioners before meetings begin. We believe that is a violation of the Brown Act. We believe those communications should be posted with the agenda with the aforementioned Brown Act requirement of 72-hour notice. Because you can't communicate with one another outside of this room by email, phone call, secret messenger, or smoke signal. And the point here is once you've begun to do that, you've violated the Brown Act. And if I can get a clear-cut memo from County Council that you're not going to do this anymore, I'll drop it. If not, we will see you in court, and this is going to be easy because, Chairman Christie, you've left a paper trail. So we would hope that your conduct would be above board and people would feel they're going to get a fair hearing because their lives and their livelihood is at stake. Thank you.
Thank you, Mr. Caldwell. Before we go on, we need to have a little discussion about decorum in this room. I realize that for many of you this is the first time that you're here, but applause, booing, verbal outbursts from the audience will not be tolerated. It's not appropriate, and it doesn't help your cause. So I understand that emotions are running high this morning, but it will be very well received by this commission if you can keep the expressions of those emotions to yourself. Mr. Whitney, you're our next speaker, followed by Eric Greening.
Thank you, Madam Chair, Commissioners. Good morning, Charlie Whitney again from east of Santa Margarita. We've had some interesting words of wisdom here this morning, and we're just getting started. I would have to concur with much of what Mr. Caldwell said, who preceded me here at the podium. The grand jury does not investigate every complaint that it gets. For the grand jury to release 2 reports within about 4 or 5 years, essentially concerning the same individual on the same commission, is kind of extraordinary, because once they feel that they have addressed an issue, they don't like to address it soon. Obviously, complaints have been coming in at a pretty good pace, and apparently they felt the need to investigate this individual once again. It's easy to understand how someone who has a life that's been steeped in activism can certainly lose perspective on what is the difference between bias and opinion. And I think that this is an important point as we move forward, and hopefully the commissioner who was investigated by the grand jury will take to heart the comments that were made by county council, and maybe some changes can be made in the way you do business here. Due process, two parts of due process I think that are very troubling to me that were brought up in the report are ex parte contacts and bias. There is a history of bias on the part of the planning commissioner who was investigated. Everybody knows who it was. There's a paper trail that goes back at least a decade, not only against certain projects on certain properties, but against certain individuals who own those properties. Back last fall, the planning commissioner made a statement before the review of a project on a noted ranch in the North County, denying any involvement as an activist or as a member or representing an organization called SMART, which opposed just about everything on the Santa Margarita Ranch, when in fact there is a paper trail there as well that shows that there was extensive involvement. I think that's where the bias comes from, and I would hope that the planning commissioner who was investigated would look at some of this and possibly take a different tact in the future. Thank you so much for your time.
Thank you, Mr. Whitney. Eric Greening is our final speaker on this item.
I'm Eric Greening, and I would point out that the grand jury, in investigating repeatedly, has found no evidence of malfeasance. It may have made a few constructive suggestions on procedure, but it has not found any evidence of malfeasance on the part of any commissioner. I believe we have an excellent commission right now with a wide range of views, a wide range of experiences, everything from deep urban planning to production agriculture is represented on this commission, and I do believe it's very effectively chaired at the present time. I also don't believe there's anything wrong when a project is coming before a commission and a state agency whose review is necessary to get a complete view of the project has not been heard from, to make sure that that state agency is heard from before coming to conclusions. There is no evidence of any telegraphing of content of what should come out of an agency's report, just making sure that the agency is aware that it needs to be heard from. So I think that's part of being a responsible commissioner. I think that we may want to develop some processes for when it comes to the attention of a commissioner that someone who needs to be heard from has not been heard from, what is the exact protocol for contacting, CCing, et cetera, that would apply to anyone and everyone. But I don't think anything was done with biased intent or biased outcome. There is obviously a range of opinions, a range of personal philosophies on the commission. There always will be, always have been. But when I compare this with past commissions, for example, where someone deriving a pension from a particular business nonetheless voted on a project from that business, we've seen nothing like that with this commission. We also have a commission that works well together, sticks to the issues, exchanges opinions in a way that always focuses on the project and not the personalities. And I just have to say I'm very pleased with this commission, and I hope you can keep working effectively. The grand jury found no malfeasance, no wrongdoing, and I hope that that particular phase stops there. Thank you.